So here we go. I will add a few reflections to what Christine has said. I mean, my title is about the negotiations a bit after. Obviously, we don't know what's going to happen because the opinion and the consequences of the opinion are still examined. The opinion is clear, of course, about the outcome, about the Singapore agreement, but each agreement is a bit different. There are different options about how to manage the different parts of the agreement. I will come back to that a little bit later. Before going there, I need to explain a few things about the opinion that will have to influence, of course, the choices that first the Commission, because the Commission has the power of initiative, but later on also the other institutions will have to discuss. About the opinion itself, I mean, just a few things, very little about the parts which are, let's say, less controversial as to the afterwards, which is all the parts where the court concludes that competence was exclusive. Well, we know very well what exclusive means. That means basically it's only for the EU. Member states cannot really be party to areas which have become exclusive under 3.1 or 3.2. That is very clear. There are still a few things in the opinion which are interesting. Of course, many have been already underlined by Christine. On the issue of, for example, sustainable development, I think that the passages there which are crucial, the court takes into account a somewhat evolutionary interpretation of commercial policy, common commercial policy is. To me, there is a paragraph which is quite telling about the reasoning of the court, which is 163, the one that basically says, look, it cannot be that something is common commercial policy if you're just liberalizing trade. But if you do it under certain conditions, such as, for example, the other party must display some standards, or if you try to influence those elements that may create some competitive advantage or disadvantage, such as environmental rules or social rules, then it is outside it. It's 163. And then again, this idea is repeated for intellectual property and also for sustainable development, that trade on equal footing. Which is precisely the basis which allows the court to have a very evolutionary, very modern interpretation of common commercial policy. Today, trade, the competence on common commercial policy cannot be just to regulate customs, liberalize trade, but whenever liberalize trade under certain conditions, then no, the conditions is for member states. It doesn't make any sense whatsoever, because you are precisely governing trade, and that is precisely the language and the terminology which has been more and more accepted, liberalizing, promoting, but governing trade. Therefore, you regulate how trade is going to develop. In some cases, it may actually be the case that you are going to limit trade in some circumstances. But in any case, this unequal footing basis somehow is a very important idea behind some passages of the opinion. Another interesting element is, to me, the transport area. Of course, Article 3.2, there is those who can go and compare with the Advocate General opinion, was not entirely followed at that point. The court concluded that Article 3.2 apply in what is becoming little by little a somehow extensive interpretation of Article 3.2. Of course, there's one, in my view, this already started well before. Of course, little by little, the court in every single case has actually decided, in all cases where the issue was before the court after the Treaty of Lisbon, has decided that the Commission was right in considering that Article 3.2 applied. But it's also interesting that the court takes into account the commitments which are really made. It's not just enough to say, well, you're negotiating about a certain topic, but the court will have a look at what the commitments really imply in practice. That's, for example, the case for inland waterways, where the court doesn't just do as the Advocate General, who said, well, there is very little regulation about this, therefore there is no exclusive competence. The court has a look at what is really the commitment of the EU and realized that there was the commitments as regards that particular sector were minimalistic, extremely limited, the court says. And then applying opinion 108 says, well, they're so limited that they cannot really change the nature of who is going to be competent to conclude this agreement. Therefore, somehow again, a novelty, because in the sense that it really has a look at what it implies for the EU. And a final reflection on sorry, that belongs to the next point. So I will devote more time to the issue of shared competence. Why? The court says, well, there are a couple of areas. One was portfolio investment, the other one was investor-state dispute settlement, which are not within the exclusive area for different reasons. In the case of portfolio investment, the court says, well, yes, the Commission's position that 3.2 TFEU applies. No, I reject it because this refers to affectation or alteration of secondary legislation. However, the court took some time to explain what the legal basis could be then. Well, it is interesting that the court for the first time recognizes that 216 can be a legal basis. You will know that whenever we conclude international agreement, we need to have two legal bases, what we call the procedural one and the substantive one. This comes back to the 90s. There was a judgment that the Court of Justice said you have to have two, or two, at least two. Let's say one procedural basis, which is 218, and then a substantive one, the one that confers you the power to act, which is normally the one that also confers the EU institutions the power to legislate. The problem, as you may know, for portfolio investment, there is no enabling clause. There is no article providing for the EU a power to legislate. That was the issue precisely. Why? Because as regards portfolio investment, there is complete liberalization because of Article 63. Article 64 concerns other types of investment. Therefore, in a way, there was no need for any secondary legislation because the rules were already in the treaties. And that was actually one of the reasons that why the Commission said, well, in this particular case, the Commission was never suggesting that any rule of a treaty can be a common rule in the sense of Article 3.2, but in this specific case, one could consider that it was. Okay, this was rejected, but at the very least, the court had to recognize that there was competence, because one of the issues that came up at the hearing was, well, then, does it mean that the EU cannot even conclude an international treaty? Where is the power? And then the court took some time, following the advocate general's opinion, to say that power is in 216, which is a sort of legal basis whenever something is needed, and it's the one that confers on the union competence. As I said, confers competence doesn't mean that it's exclusive. And here it's even clearer. There was a previous opinion, the opinion on the Hague Convention 113, where the court explained that there was the existence of the competence and the nature of the competence. This was explained before, even before in the opinion on the ILO. But to say that was very clear. There was a section on the existence and then the nature of the competence. Again, one can see it clearly here. 216 is not about the exclusiveness of the competence, but about the fact of granting a competence to the union, which the court will say in 244 it's not exclusive, however, because the court will say because this is not exclusive, it is shared, and because it is shared, and then there is no reasoning whatsoever, the court concludes that this agreement cannot be concluded by the union alone. Because there is no reasoning, we don't know exactly what the court meant here, and I will have to explain a little bit the background of why this is important, because the common understanding of the European institutions has been that a shared competence is defined in Article 2.2, and a shared competence means that it can be exercised by the Union or the Member States, but if the Union exercises it, it's not exercised by Member States, which means that the Union can exercise a shared competence as well, of course, alone. Alone, and once it does, in the same way as you can adopt a regulation or a directive, you can adopt an international agreement. This led to the, somehow, what some people call facultative mixity, and I'm sure it's going to be discussed later on. So there we are. We all thought that, okay, being a shared competence, this implies a choice. This is what Sharpston said. This is what Advocate General Val said in the Marrakesh opinion, and this is what has been explained in detail by Advocate General Spooner in the case, in the COTIF case, 600/14. And this COTIF case is going to be crucial, precisely, to know what shared competence means and possibly what are we going to do in the future with FTAs. And I will explain a little bit why, because one could consider that actually what the court has done in 244 is to say share equals mixed. The assumption has been that share doesn't equal mixed. It may be mixed or it may not be mixed, depending on the Council decision. However, the court could say just because this is so short that it's not possible to know, it has somehow rejected this position. In a way, one could consider, well, at the end of the day, the Commission got a lot of exclusive competence, so it's not so important if this has to be mixed. Well, maybe not. One may also explain that this is just a continuation of previous case law. In other words, although Article 2.2 of the treaties was supposed to create clarity about what means shared competence. It has not. Before the Treaty of Lisbon, already in several cases, the Court appeared to be saying that shared competence means a mixity, necessarily. That's, for example, in the ILO opinion, but the other cases. However, at the same time, the Court acknowledged in several cases before Lisbon that it was possible for the Union to exercise a non-exclusive competence alone, which means then that it's a bit strange, because that means if it's not exclusive, that means that it cannot be exercised alone, but it has also said that it can be exercised alone sometimes. Certainly that's the case of what we call parallel competence, cooperation, for example, where it's also, treaties are very clear. The fact that the Union has a cooperation agreement doesn't mean the member states cannot have a cooperation agreement with the same country. Anyway, there are lots of uncertainties about what the Court has meant here. Maybe the Court has just imported the rather unclear case law on the meaning of shared competence pre-Lisbon into the post-Lisbon era, and therefore Article 2.2 either does not apply to international agreements or applies in a different way. There could be an advantage in all this as well, one can see, because this idea that it's either or, in the sense that it's either the Union or the member states, means that in the Council's view, if the Council, for them it's a political decision, if the Council decides to exercise only exclusive competence, for example, about a multilateral agreement, and not shared competence, so let's say if there are 10 articles, 5 are exclusive competence, 5 are shared, for these 5 articles, member states retain the competence. Fine, fair enough. If one has the view that shared means mixed, or rather even joint competence, as one may appear to suggest, for example, opinion 291, the ILO opinion, that means that we need to go together. That means also that those provisions, these other 5 provisions that we thought were left to the member state, actually they are not. They are also within the field of application of EU law. It's just a sort of a special type of competence that is to be jointly exercised. So that means also that the EU is party to that bilateral, multilateral agreement also for those parts. Anyway, these are question marks which are a bit unclear. So they might have some advantages, because that also means that the member states thought they were entirely free for these other 5 articles to do whatever they want. But actually, if the competence is jointly exercised, that means that EU law also applies. That means that they are bound by the Charter of Fundamental Rights, for example, and many other things that EU law also implies, such as, for example, the interpretation of the Court of Justice. But it may be also the case that actually this was a sort of ad hoc political solution adopted by the Court of Justice, where the Court of Justice said, well, yes, okay, I mean, there is such a claim that this must be mixed because otherwise this is not going to be democratic, the Constitutional Court in Germany will not be very happy, or whatever. But actually, it's a sort of very specific decision on this particular case, so that it doesn't really mean that in other cases it would not be possible for the Union to exercise alone a shared competence. Of course, one has in mind the issue of parallel competence, cooperation, where it's not an exclusive competence. At the same time, the Court already said in the 90s that it was possible for the Union to conclude alone. One could even speculate that, for example, in this case, the Court considered that it was for the Member States to also participate as regards portfolio investment, because somehow it affected in the wide sense, of course, treaty rules. So, for example, if it was a totally different area where the EU would have had competence to adopt rules internally. Remember, precisely for portfolio investment, the EU didn't have legislative competence. The only rules were in the treaty. So what about another situation where the EU would have had legislative competence internally? Maybe the Court would have done something different, because somehow it doesn't make a lot of sense that the EU can adopt a regulation or a directive in a certain matter, but it cannot conclude under shared competence an international treaty. So I'm this is pure speculation, because the reasoning is so short, possibly on purpose, precisely to leave a little bit the mystery for the following case. I think we will only have some degree of clarity when this case 100/14, Germany versus Council, is decided. Just to recapitulate a little bit this case, precisely about the situation where the Council adopted a decision under 218 paragraph 9, this EU positions to be taken in a body created by international agreement, under what is basically shared competence, because there was hardly any EU law on those particular points. So there the EU exercised competence, possibly of a shared nature, and Germany is saying basically that the EU cannot exercise alone a non-exclusive competence. Actually, well, Germany goes as far as saying that it cannot exercise at all a non-exclusive competence, but somehow it cannot exercise a shared competence in this way. As I said, there is a very long opinion 2 or 3 weeks before the opinion, to advocate general opinion in another case. There are many opinions here. Before Singapore Spooner, where he explains, basically, shares the Commission's point of view, and to a large extent also the Council's point of view, that it's possible to exercise, of course, shared competence. On ISDS, I will be a bit shorter on that. The reasoning is a bit different here. The Court doesn't say it is shared and therefore, let's say, it must be mixed. It's the opposite. First says, well, what you're doing here cannot be considered as ancillary, unlike dispute settlement between states, because you're taking away competences of national courts. It is always formulated as an issue of competence and not substance. That's very important, because the Court says, no, I'm not suggesting here examining issues of substance. And therefore, the Court says this cannot be done without the consent of member states, and therefore, this is a shared competence. So here it's not, first I define the nature of the competence and I see the consequences. First I define the consequence and then I see a little bit, I define the nature. Again, it's still not very clear if the Court is suggesting that this would be a national competence. In the sense, one could interpret the Court judgment as meaning that because the acts that would be challenged before national court would be the national legislation or decisions, somehow, yes, this is not something that can be integrated in a EU-only agreement. That would be odd, but yeah, why not? One can interpret that. Because actually the other part on state-to-state dispute settlement may also cover acts of national authorities. So that cannot be the explanation. No? The explanation cannot be that somehow the defendant or the relevant act to be contested was a national act. It must have something to do with the idea that you cannot just deprive maybe le justiciable or certain parties of certain rights, of certain roles of national court. Again, there is a lot of uncertainty about exactly what this may mean in practical terms in the future. It's also very unclear because one could consider that in reality, although the Court changes the order of the reasoning, it is a little bit the same thing as for portfolio investment, what I was referring before about may the EU have conclude an international agreement alone on this matter or not? And therefore all the problems I described before about the future and the interpretation and the possible relevance of other future cases will come into play. Anyway, as I said, what is interesting is that the Court makes sure that member states will have to give its consent. So it defines this issue as an issue of competence, the idea of taking away some role of national courts. It doesn't, as such, quote Opinion 1009, of course, on patents, but maybe because it keeps the possibility to examine this issue later on. So, but again, we are still left wondering whether the assumptions that we all had for several years that it was possible to exercise alone a non-exclusive competence is at all possible. Another interesting element is that actually, if you see the reply of the Court of Justice at the end, it doesn't say anything. It just defines the nature of the competences. But the famous sentence where the Court adds in 244 and in the paragraph, I don't remember, 293 on shared competence for ISDS are not to be found there. No? I didn't say they are obiter because obviously I think the Court clearly had wanted to include these sentences there to reassure member states that even if the EU was going to get it, it was less Christmas somehow. The Commission got a lot of exclusive competence, member states got mixity, that's what they wanted. So, voilà, that we will have some issues for the future. And precisely talking about the future, one can imagine many different ways of shaping this agreement, what to do with this new generation of FTAs. First, one must bear in mind that each case is a bit different. Singapore agreement is different from the Canada agreement. Canada TTIP are more similar. Vietnam agreement is different. What we may negotiate with Morocco as a deep and comprehensive free trade agreement will be different. So it's quite clear that what we have we can read in the judgment will guide many of these issues, but it is never to be excluded that we may still have to dispute or discussions about whether or not common commercial policy still covers some issues which were not so prominent in Singapore and maybe prominent in some of these new agreements. As regards, that is for, let's say, the areas where there is exclusive competence either for 3.1 or under 3.2. Certainly on 3.2 it's perfectly possible that the type of commitment we may have with some countries that go beyond what was foreseen in the Singapore agreement, and therefore the issue may arise inland waterways, for example. I don't know. Certainly it's not so much of an issue with some of our, it's more of an issue eventually with Switzerland, I'd say, but not necessarily with Singapore. As regards the rest, so the areas where the court said, well, you have to also, you will also need the agreement of the member states, so the union cannot alone conclude this agreement. There are different options, of course. You can imagine just to have two separate agreements, to renegotiate some of these agreements, to just limit them to what is EU exclusive competence or EU-only competence. It is, as I said, two agreements, one agreement. This is something, sooner or later at the end, obviously, a decision will have to be taken. It depends also on the reaction of the Council. If you have two different agreements which are somehow still related, one for the EU-only part, the other one, smaller one, for the let's say, mixed part, even if they are not formally the same agreement, member states may, in any event, link them so that they may not be happy to approve the EU-only agreement, even if it's by qualified majority, until the other one, for example, goes ahead. So there is still political linkage that can be made here. Member states may tell the Commission, no way you are going to negotiate a somewhat smaller agreement without these bits here, for a number of reasons. So, I mean, it will depend very much on what different political actors in the process will have to decide. And as I said, also for each international agreement, the geopolitics may be different. Member states may be more interested in concluding a certain agreement quickly than maybe another type of agreement. So it's, as I said, too early to say, and I would say also that in order to have a more informed decision about the different legal possibilities, we will have to also have a judgment in the COTIF case, 600/14, to have a better understanding of what shared competence means and whether this opinion and say how the court deals with portfolio investment and investor-state dispute settlement was, say, something exceptional, very specific, where the court required mixity for reasons which are not explained, but say for some reasons, or whether this is really a position of principle, therefore something, a lesson to be drawn for the future in terms of defining the scope of competences. You have to bear in mind that this is an issue of principle that concerns certainly this type of very new free trade agreement, but it also concerns other types of agreements, either multilateral or bilateral partnership and cooperation agreement we may have. The partnership and cooperation agreement, the understanding has always been that because they are basically parallel competent, we call parallel competence, we still rely on the case on the 19th that said very clearly that it's something that the Union can conclude alone. But this opinion may be read by those member states who are more keen on trying to avoid or, let's say, to have mixity at any price, as meaning that whenever the competence is not exclusive, mixity is mandatory, for example. But I'm sure we will hear more about that. And I think that's all what I wanted to know about the future, which, as I said, is not clear at all because a number of political decisions will have to be made about. And I think that this will come little by little, one by one. First of all, the Commission will have to decide what to do with this case, Singapore, and then the rest will eventually follow. For CETA, it's already mixed. I mean, it was decided for reasons, I don't say if it was legal or political reasons, but certainly for reasons that it will be mixed agreement. The other TTIP for the time being is frozen. The other agreements coming, like, for example, Vietnam, where some decisions will have to be made. But I think the first decision will have to be made, of course, quite logically, of course, about Singapore. Thank you.